Welcome to Rock Solid IP, expert strategies for creating real value from your creativity and innovation.
Hi, welcome to Rock Solid IP, expert strategies for creating real value from creativity and innovation. I'm Kendall Trotsky, and I'm here today with Rob Wells from Rock IP Law Firm. Hi, Rob. How are you today?
Great, Kendall. How are you doing today?
I'm great. Thank you very much. But I really am curious and want to get started talking to you about patents. You can help me understand it. What exactly is a patent and how does it differ from the forms of intellectual property?
Okay, so let's look back all the way to when the Constitution was being created. Patents and patentability is actually protected specifically in the U.S. Constitution. The goal in patents is that the government and really society as a whole wants to expand knowledge and information. So what they've done in order to try and protect that, because otherwise people wouldn't want to keep all of their technology secret, in order to kind of expand knowledge and information worldwide, nationwide and worldwide, we create a patent system. And the deal is this: if you will tell us, the entire world, how you did what you did, what is involved in the thing that you invented, we will give you a 20-year monopoly on that idea. In other words, we'll give you a 20-year period of time when you can prevent other people from doing the thing that you have told us how to do.
20 years?
20 years in the United States from the time that your patent issues until it expires. 20 years later, that is considered knowledge that's in the public domain. But it also allows people to, because that patent is published and available, during that 20-year span, everybody can read it and find out all of the information about what it is that you've invented. So they can use that and continue to advance technology, continue to advance innovation, which is really the goal of a patent.
That is 20 years is amazing to me. And what are the different types of patents available?
That's an excellent question too. So there are, in the United States specifically, there are utility patent applications or utility patents, and then there are design patents. The two protect different things. A utility patent protects the actual how of what works. So they'll protect systems, they'll protect apparatuses, they'll protect methods. They can even protect business methods. They're protecting the actual strategy, the actual technology behind how it is that something works. Compare that to a design patent. A design patent protects the ornamental design of an object. This is the look and feel of a particular product or feature. When you look at an iPhone, it has a particular distinctive look and feel. And a long time ago, some of our viewers might remember, there was a battle between Apple and Samsung. That battle had to do with the ornamental design of the phone. In fact, it was a phone with rounded corners, and that was the ornamental design. There wasn't much technology involved in it. It was simply the look and feel of the phone. A lot of people have robotic vacuums around their houses, and those are protected by design patents. A lot of car companies protect their designs for their headlights and their bumpers and other things. Those are all just in the ornamental design, the look and feel.
So they can patent a rounded corner on a phone. Apple
successfully did it and protected it. And if you look at any Samsung phone now, they don't have rounded corners.
That is very interesting. And I've heard about a plant patent.
That's absolutely true. So in addition to just the utility patents, you can get a plant patent, which is based in how a particular plant is crossbred or evolved and developed. So that can also be protected.
Very interesting. How do startups determine if their ideas is unique enough to patent?
So there are two schools of thought related to what I'm about to talk about. One school of thought says we should know everything we need to about what is actually out there currently in the industry, what's already being done, what's already known. It's called we do what's called a patentability study to figure that out. We'll go ahead and we'll run searches. They can be, depending on the industry and depending on your technology, they can be somewhat costly. Typically less than about $10,000, but still somewhat costly. But out of that comes all of the intellectual property, the patents that exist, worldwide, and at least in the United States, that discuss the technology that you're trying to get involved with. When you do that, the advantage that you have is that then you can design a patent, create a patent that makes sure that it gets around all of the existing intellectual property, claims things that are unique, and also will let you know what size of a margin you have over the existing intellectual property, how much white space there is, so what you can actually claim. That can be really, really valuable because it can result in a stronger patent. The downside to that, and here's where the other possible option comes in, is that when you know about any intellectual property assets, any art that exists, you are required when you file a patent application to notify and tell the Intellectual Property Office, the USPTO in the United States, about any intellectual property or about any references that exist that may be relevant to your patent. And so the other school of thought says, hey, it's the patent office's job to review my patent application. It's their job to take a look at my innovation and the claims that I have, and it's their job to find potential prior art. I'm not going to spend extra money to do their job for them. That should be their responsibility. Your approach differs and can differ. The strategy that you use, whether you conduct a patentability study or choose to just go ahead and file a patent application, those can differ based on the technology that your company is involved with, but also how much of a budget you have to spend on intellectual property. For a brand new startup company, it's probably not advantageous to spend that much money on top of filing your patent application to make sure that you've got all of your I's dotted and all of your T's crossed. But your strategy there can and will evolve over time as you gain rounds of funding and whatnot. It can be more valuable and more important to run that patentability search.
That brings me to how patents can give startups a competitive edge in their market. Will it give them that competitive edge in their market?
Yes, absolutely. Patents can and should give you a competitive edge. And that's one of the things we do at Rock IP. We're concerned with and making sure that the patents that we obtain for our clients are not just for a scoreboarding exercise. They're not just there so that you can put them on the year-end statement or announce them to your board or potential investors. They should provide you with a competitive advantage. When you file a patent application, it's important to consider how your patent will be used and how it could potentially block competition. When I talk to a lot of my clients and I send them a draft patent application, one of the questions that I ask when I send it to them is, take a look at the claims and tell me if you can think of any way to get to your end product, to your design, that doesn't infringe on the claims that I've written. And if they come back and say, yes, my job isn't done, then my job is to go back and to redraft those claims and to come up with something that can secure my client's niche a little bit better, my client's innovation. So there's not a way around it.
What steps should a startup or a company take to file a patent?
The first is to establish a bit of a program, kind of a regimen, if you will, for making sure that they identify their intellectual property. The very first thing that a company needs to do is to make sure that on a monthly, quarterly, biannual, you pick the time frame basis, you're taking time to sit down and review all of your intellectual property. Intellectual property, not just including patents, comes in a variety of flavors. There's also trade secrets specifically. And so evaluating what all of your technological innovations and advancements are and what the value of all of them is, everything from your customer lists and your relationships and your business dealings, your deals, your contracts, all the way up to how your technology is actually being implemented. And then to categorize those and to note what is in the trade secret category versus what is in the patentable category, and then to have a plan in place to go ahead and pursue patent protection. Your IP attorney can give you a rubric or an invention disclosure form to help you in guiding you along the process of disclosing your invention and helping you to maximize protection for it.
And you said review it certain times at whatever they choose. Do you have a recommended time frame they should be reviewing that, like you said?
It does depend on the size of the startup and how quickly the startup company is moving. Most of our clients are lean startups. They're moving very, very quickly, and they're pivoting from one idea to another, oftentimes in and around the same exact solution that they were working on. So we really suggest and recommend that we meet with our clients about once a month to consider where they're at in the process and if there's any additional intellectual property. We have other clients that have things in kind of a better progress. It's a little bit more of a slow roll. And so for those companies, a quarterly meeting works just fine.
Okay. That's helpful. Very helpful. And how long does the patent application process typically take, and what factors can influence that timeline?
So in terms of patents, there are a couple of different kinds of utility patents. There's a provisional patent application, and then there's a non-provisional application. A provisional patent application won't ever be reviewed by an examiner. It won't ever result in a patent. It is simply a way to get what's called priority, or a claim as to who was first to get to the patent office, who has the rights to an idea. From the time that you file a provisional patent application, you get 12 months to file a non-provisional patent application. The non-provisional patent application is going to be examined by an examiner and can result in an issued US patent. There are a couple of different strategies that work here. In one circumstance at the US Patent Office, you can go ahead and fast track your patent application. It's called a Track 1 application. You can pay a little bit of extra money, and then you're guaranteed that you will be treated, your application will be examined, and you'll arrive at a quote unquote final resolution on your patent application within 12 months. So what that gets you is not actually that you'll have a final answer as to whether you are patentable or not, but you will get at least two office actions within a 1-year period. And those typically run at about a 6-month interval. So you'll probably see your first office action at about 6 months, and then you'll know whether or not you have a patent, or you'll get your second rejection, or you'll get an allowance within another 6 months. So you'll right at that 1-year mark. If you don't go with the Track 1 approach, then it takes 18 months before your application is published. And at the United States Patent and Trademark Office, they're also undergoing a pretty significant backlog, and they have been really since I've been practicing patent law. It takes about 18 months before an examiner has the opportunity to take a look at your office action and start reviewing it. So a year and a half before they even start to look at and give you your first office action. If you go with the Track 1 approach, you might be able to see a patent application within 18 months or so. If you go with the non-Track 1, the traditional patent application, that's going to be a minimum of 18 months and probably closer to 2 to 3 years.
Is the benefit of one or the other contingent upon the company and the type of patent they're looking for what product?
Yes, absolutely. Depending on our client and their needs and the industry that they're involved in. So for example, in an industry like the electronics industry or the high-tech, quickly moving industry, we highly recommend that they go ahead and pursue Track 1 protection, because frequently technology is moving so quickly in those industries that there is often, within a year and a half, the innovation might have already been surpassed. And so you want to get protection on your IP, on your patentable idea as quickly as you possibly can. It's worth the extra money to go ahead and skip the line, so to speak, and get your patent examined quickly. Compare that to the pharmaceutical industry. In the pharmaceutical industry, most of the value of a pharmaceutical patent is at the end of the lifespan of the patent. At the very last year, at the very last month, most of the income is coming in there. It makes all the sense in the world in the pharmaceutical industry not to Track 1 your patent application, because then you extend that examination period when you're undergoing FDA trials, et cetera, and before you can actually market your product, and waiting until you actually have the patent in hand and you've moved along the process and you can retain more lifespan on your patent and recover more value from it.
Well, that is very helpful information, and we may have covered it in a sense, but what are some of the misconceptions that startups might have about patents?
One of the big misconceptions that a lot of startup companies have is that if they file a provisional patent application, they have a patent. You don't have a patent just by virtue of filing a provisional patent application. There are companies that you may have seen even on TV that claim to help you get a patent, or to at least file for patent protection quickly, and they can do it in a 24-hour period. And unfortunately, we have several of our clients who come to us and say, we have a patent. And in reality, what happened is that they really just got a patent application filed. They got a provisional patent application filed, and it's invalid after 12 months. And we often come into the picture after that's occurred. And so that money's already been spent in their there is no protection there. Other misconception that a lot of startup companies have is that they shouldn't try to protect their patentable ideas, that it's just not worth it. That is a misplaced conception. The value that you generate through expending your sweat equity, you've paid for your R&D, you've paid for your teams to develop ideas and concepts. And those don't necessarily need to translate into, a battle at court over whatever innovation you've created. They can peacefully transition into licensing agreements, into other sources and forms of revenue that come in. But it does make a lot of sense to protect your bottom line, to protect your investment in R&D, and to take that on. One of the other ideas that people unfortunately get, especially in startups when they're first approaching intellectual property, is that it's just too expensive. It can get expensive. I'm the first to admit that. But at the same time that it might be expensive, it can be expensive on one end, but there is a strategy for every single startup company along the lifespan of their company, along their startup journey, that can meet them right where they're at in terms of the budget that needs to be expended in order to achieve the best protection that they can get and afford at the stage that they're at. And every one of those is worth it.
Good to know. And real quickly, how does it differ? How do patents differ from trademark and copyright?
That's a great question. So patents, as we talked about earlier, are protecting the actual look and feel for a design patent or the actual technology of how something works. We're actually, as we discussed, protecting providing kind of a reward for disclosing the information or the advancement in knowledge that you have gained as an inventor. Trademarks, on the other hand, totally separate from a patent. The goal in a trademark is not to protect or provide to the brand owner. The goal is in trademarks to actually protect the consumer and the consumer's ability to recognize the source of a good or service. If you pulled into a store that had these great big golden arches and you tried to order your McNuggets and they said, "I'm sorry, we sell tires here," you'd be a little bit confused and a little bit frustrated, right? So the goal with trademark protection is to make sure that the consumer's not confused, that you actually do know where your goods came from, who made them, and to know the quality that was invested in and put into making the thing, so that you can rely on the indication of where it came from and what its name is. Copyrights are directed towards making sure that we protect the artistic creations of artists, and that is whether it's in a written book or audio, a recording, or a CD or music. All of those types of things are protectable through copyright, but they're very different from patents and from trademarks.
That is good information to know. Rob Wells with Rock IP. They're located in Washington, D.C. They specialize in intellectual property law. They work with their clients to help build, manage, and monetize their IP portfolios and strengthen and protect the foundation of their innovation. Rob, thank you so much for being with us today. It certainly was a pleasure.
Thanks so much, Kendall.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.